Good morning, everybody. Everybody hear me? Microphone working? Fabulous. Well done, guys. So we're going to take you on a little whistle-stop tour of developments across Europe. I'm joined by a fabulous panel from different regions across the continent who will be able to give us a bit of an insight into their different regions. So I'm just going to start off with asking the panel just to introduce themselves. So Sarah, could I start with you?
Yeah, good morning everyone. It's great to be here. Sarah Murphy is my name. I'm a partner, disputes partner, and co-lead our disputes investigations group in A&L Goodbody in Dublin, Ireland. Our group specialises in broad spectrum of commercial disputes and have been involved in some of the seminal mass claim mandates that have come before the Irish courts in recent years.
Thanks, Sarah. Jan?
Hi, I'm Jan Buschfeld. I'm a litigation partner with Mayer Brown in Germany. I'm doing also a quite broad variety of commercial disputes, including commercial international arbitration. When it comes to mass claims, I've mostly done cardiac damages claims over the last 10 years of my career, so that's when it comes to mass claims in Germany, so the type of claim that I've done the most.
Thanks, Jan. Rita?
Hello everyone, great to be here. My name is Rita Samoreno Gomes and I am a partner at PLMJ, which is one of the 3 largest independent Portuguese law firms. I come from a commercial banking and litigation background, but in recent years I have been focusing in class actions, working essentially on the defense side. I am currently, I did my calculations yesterday, I am currently defending 18 class actions, which frankly gives me very little time to do much else. I represent a wide variety of clients, from local corporations to international corporations, financial institutions, the big tech, entities on the food and beverage sector, on the health sector, etc. It's great to be here and to participate in this interesting discussion.
Thanks, Rita. And Catherine?
I'm Catherine Longeval. I've got a frog in my throat. I'm a partner at Bael and Bellis, VBB for short, in Belgium. We also have offices in London and Geneva for competition and trade. I'm the head of our dispute resolution department, where I do, like half the people in this room, I think, complex cross-border litigation and also arbitration, where I both represent parties and work as an arbitrator for the ICC and the Belgian Arbitration Institute, CEPANI. I am involved in several Belgian class actions. There's way fewer in Belgium than in one of the Walhallas of class actions in Europe, both class action before the adapted regime of 2024 and under the new one. And I'm very much on the defendant side in these class actions. And the last thing maybe you should know about me, I have a second hat, which is life sciences. I'm also a life sciences lawyer focusing on regulatory life sciences work. Voilà.
Yeah, fantastic. So a great mix of jurisdictions, panel experience, etc. So the collective redress regimes across the UK and European regions were established to hold business accountable when damage is caused. The Representative Action Directive in Europe remains the anchor. It sets minimum EU-wide standards for representative actions to protect consumers' collective interests. There were 97 claims filed in 2024. And this number has continued to grow at pace throughout 2025. So let's crack on with the first question. And Rita, I'm going to come to you first, because obviously Portugal is a hugely developing collective redress regime. So it's been interesting to see how regions have adapted collective redress across Europe, and in some instances applied the Representative Actions Directive. If you wouldn't mind, Rita, just talking about in Portugal the jurisdiction and the progress you've witnessed over the last few years.
Yeah, sure. It's obviously a very interesting question because, as probably this audience knows by now, despite the harmonization efforts at the EU level with the Representative Actions Directive, I think that Europe is pretty much still a patchwork of very different regimes, which is something that will likely become apparent from this discussion, and this is one of the reasons why these gatherings are so important. Now, in Portugal, as some of you already may know by now, Portugal class actions market has been on the rise in recent years, at least for the last 5 years. According to the CMS report that was quoted a while ago, Portugal, for the last 2 years, has surpassed the Netherlands in terms of number of claims, but also in terms of the amount of damages sought, now being in the forefront of the continental Europe class actions market, and I will come to the numbers later on, but this tendency is showing no sign to slowing down, which is very interesting, and this may come as a surprise for some of our audience, because probably they are not so familiar with the Portuguese jurisdiction, although I see a lot of Portuguese faces here, which is also a sign of how vibrant the Portuguese class market is currently. But as I was saying, this may come as a surprise for some, because Portugal is really a small and peripheral European market. So it was not something that we would predict a couple of, well, five or 6 years ago. The reason for this phenomenon, as usual, is a combination of factors. Portugal, as you may know, has a long-standing collective redress mechanism in place for many years, but nevertheless it has transposed the directive in late 2023. And I think that the main reason why Portuguese is the new, well, at least one of the major hubs in the class action market in Europe, continental Europe, is because we are an across-the-board opt-out regime. We already were before transposing the directive, and this is unique in Europe. Aside from the Netherlands, I think that Portugal is the only jurisdiction that is a true opt-out regime, except for non-residents in which we are opt-in. So I think that this is obviously a key driver for the attention that claimant-related stakeholders have given to the Portuguese market, but also other factors contribute to this. We have an extremely claimant-friendly regime. Very quickly, we don't have a certification stage. I know that yesterday there was a panel on certification, so you probably know by now that we don't have a certification stage, which means that it's very easy for a case to proceed to trial in Portugal with very little procedural hurdles for consumers, for claimants, sorry. We are also a regime that is extremely open to litigation funding. So far, Portuguese courts have not questioned the legitimacy of litigation funding and have been generically accepting litigation funding agreement with very little restrictions. We award global damages, and the unclaimed amounts do not revert back to defendants. They go generically to state funds. We are an extremely cheap jurisdiction. In practice, we don't have a loser pays rule for claimants. We don't have adverse costs, so it's very cheap to lodge a class action in Portugal. Also importantly, there is no actual link between the damages sought and the litigation costs, which also facilitates the lodging of very high amount class actions. So as you may see, we are an extremely claimant-friendly regime. I think, in my opinion, we are an unbalanced claimant-friendly regime because although we don't have punitive damages, Portuguese collective redress is about compensation and not about punishment. We leave that to the public enforcement entities, which, as we all know, are very strong, at least at the EU level. So punishment is with public enforcement, but we have very little controls on abusive litigation. Due to this certification stage, we don't have a proper early dismissal stage, so it's very easy, as I said, for a case to proceed to trial, and it's very inexpensive for claimants because we don't have a loser pays rule for claimants. So I think that these issues should be addressed by the Portuguese legislator to probably in the future make the Portuguese regime a little more balanced which at this stage I don't think it is.
And without that certification step, how many cases go to trial but fail?
We don't. Another issue on the Portuguese landscape is that Portugal is an extremely slow jurisdiction. So we don't have. We have two very old decisions on the merits in class actions, but in relation to old class actions. So the boom that has started in 2020 has not given rise to any decisions on the merits yet. So that question remains unanswered, but I will go through the numbers in a follow-up in another round.
Yeah, perfect.
But we have many cases, and almost all of them are still pending because we don't have, Portuguese courts don't assume a gatekeeping role, so cases just proceed to trial.
Great. Thanks, Rita. Really interesting, and fantastic to see the growth of Portugal as a regime. Catherine, can I move to you?
Well, not if you're a defendant.
Well, no, indeed.
Just saying. Because I'm going to be wearing two hats here today, Belgium and the Netherlands, because as you remember from our initial discussions, I was delicately told that maybe Belgium was not the most interesting jurisdiction. So I've taken on the role of Dutch expert as well for today, so I thank my Dutch colleagues who prepped me for this session, but bear with me, I'm not a Dutch qualified lawyer. So Belgium is in huge contrast to Portugal. In fact, when the Belgian legislator was implementing the RAD, and that law was adopted last year, one of the things they said in the preparatory works was, what we do not want is a US-style class action system in Belgium. That's why, whilst they're trying to open the class action system more, they're still very wary of having this onslaught of cases that would burden the long-suffering Belgian judicial system even more. So what we had just before the RAD was a situation where the rules on admissibility for the claims vehicle, for the claimants, was so tight, so tough, that only basically one Belgian consumer protection organization, Destincorp, was bringing class actions. I mean, 9 out of 10 class actions were brought by Destincorp. Now, that's been opened up more. You need to meet certain criteria, but it's still quite difficult to start a class action. Not anybody can just bring a class action. We have 4 stages in the class action procedure. The first one being the admissibility stage, where the court is going to check, first of all, whether the claimant meets the admissibility criteria, like not-for-profit and so on. We have, unlike Portugal, a generalized opt-in system. Only opt-out if the parties agree, as if that's ever going to happen. Third-party funding is allowed, but there's very few rules on it, and it's still very much underdeveloped in Belgium. One thing, though, and I'll come back to that later, which has been a really marked development because of the RAD, is that in Belgium, one type of claimant that is now allowed to bring class action is a so-called cross-border qualified entity under the RAD. So each member state can certify local foundations, claims vehicles that are established in its jurisdiction to also act as cross-border qualified entities to bring class actions not only in their own country, but also in other EU jurisdictions. So what we've seen is, for example, the Netherlands, where claims vehicles, of course, have a lot of expertise already because of the WAMCA being so favorable to claimants, and the Dutch regime in general. Dutch claims vehicles obtaining cross-border certified status in the Netherlands from the ministry, which frankly only does a very cursory review of their standing, and they are now rolling out their Dutch class actions across the EU. So what you see, and I will come back on it later, is a trickle in Belgium that's going to get much bigger of Dutch claims vehicles rolling out their Dutch class actions across the EU against tech, but they will also be doing it against other kinds of companies. I'll come back to that later.
Thanks, Catherine.
I also need to talk about the Netherlands.
Carry on.
Yes. So in the Netherlands, you have the WAMCA. Of course, you've heard about that law already several times yesterday as well. It was, until recently, the most popular destination for class actions in the EU. Now, of course, Portugal is hot on its heels and has overtaken it a number of claims, but still, at the moment, 30% of all pending class actions are pending in the Netherlands. Tiny population, 16 million, but 30% are pending in the Netherlands. Filed claims value over 36 billion, half of which is in class actions against tech companies. What is the reason, I wonder, for the popularity of the Dutch system? Of course, it's opt out as well, like in Portugal, apart from foreign class members. They have to have opt-ins. That's the only exception to the opt-out, it's foreign class members. Also possible in the Netherlands, and it's going to happen even more now, I think, is the possibility to combine different claims. Say you've got 5 claims vehicles, all bringing a claim against the same company for very similar or almost identical alleged violations. In Belgium, for example, the court would say, well, only one of you can proceed to trial. We're going to have to pick the most competent, well, the most appropriate one. In the Netherlands, the court can put all those cases together and then designate what they call an exclusive group representative. It's not really an exclusive one, it's a lead one. And they can even have a lead one for several subclasses of the group. So that's also something which makes it interesting for claims vehicles to file suit, even if they know that another claims vehicle is doing or plan to do the same, can all be bundled by the court. And there's also, I have to say, from my experience, having looked at Dutch class actions which are in parallel with the ones I'm working on in Belgium, a very liberal attitude of the Dutch courts about what constitutes not-for-profit claims vehicles, or what constitutes homogeneous, bundable damages of the claimants. So there's a very liberal interpretation of the rules, in my humble opinion, in favor of claimants, all of which makes that following the RAD, you're going to have even more class actions, I think, in the Netherlands, especially with these claims vehicles operating out of the Netherlands and rolling out their cases across Europe.
Thanks, Catherine. And it's not surprising that GLG have taken us to Amsterdam, obviously to Lisbon, and into the UK in terms of areas of interest that are developing as activities. So Portugal and Amsterdam, Portugal and the Netherlands, and obviously the Belgium jurisdiction. Great to hear about those. Jan, I'm going to come to you with regards to Germany, which obviously is a slightly different jurisdiction when it comes to collective redress.
Yeah, so Germany implemented the Representative Actions Directive, or the RAD, in October 2023. So actually we just celebrated 2 years in the RAD regime in Germany. Before that, the German collective redress tool was the so-called Model Declaratory Action, which was introduced in 2018 as a response to the diesel claim, or to the flood of diesel claims coming up at that time and before. So that instrument, the old one, only allowed for declaratory relief, and the court clarified some key issues, but then consumers still had to lodge and file follow-up claims to get their money. So the RAD redress action now changes that. So it allows for monetary relief within the collective process. So that's a big step forward, I think. Second, it goes beyond the scope of the RAD because it's not limited to the EU instruments listed in the annex to the RAD, but it goes beyond that and covers all types of civil claims by consumers and also small enterprises which have less than 10 employees or less than 2 million in turnover. It is opt-in, so consumers have to proactively register in the relevant court register with their claims. And roughly it has 3 phases. In the first phase, the court looks at the merits of the case, and if the grounds for the claims is given, then the court issues a first declaratory judgment on the merits. It moves then into a settlement phase where the parties can try to settle the case. If that fails, then the court will issue a judgment on the quantum, on the amount, and on the total amount, which is then in the last phase allocated by a trustee to the consumers which are registered. So that's roughly how it works. I think it's a qualitative step forward, and it's really the first regime in Germany which you could call a real or true collective action regime. Nevertheless, though we have this now for 2 years, if you have a closer look, you will see that there is not so many claims which have filed since then. So since October 2023, we've seen eight actions under the new regime registered in the court register. There is a 9 case filed in September by a Dutch entity, so foreign entities can also file redress actions in Germany. So what we are talking about is like 4 to 5 filings per year, so that's not close to Portugal or the Netherlands. It's still more than in Spain, likely, but it's not a lot. So why is that? If we now have actually not a perfect tool, but none of these regimes are perfect, I guess, but it's not working that well. And I think the main reason is, besides, of course, the cultural thing, so Germany has not been a class action friendly country for years. There was also a lot, as in Belgium, there was also a lot of skepticism by the legislature against anything which could be similar to a US-style class action. And Germans are not particularly good in advertising new things which are now known, in particular in the legal sphere, which is still quite traditional. But I think this core issue is that it's not very attractive for claimant law firms, and it's even less attractive for funders, because of this skepticism against US-style class actions, the legislator put a cap for funders up for the funder share of a maximum of 10%. So from what I've seen, the normal share is like 35% for the funder. So 10% is not attractive at all. So maybe there are still some funders around who can comment on that. And then the entity itself, it must be non-profit, and it must fund these cases somehow. So that limits their funds and the amount of cases that they can bring themselves. So I think that's the main reason, and that's why we still in Germany see not so many redress actions. It will have its place, it will remain, but I think it will stay more fragmented in Germany into like having a couple of these redress actions. Then we have individual claims still, and the third pillar or the third category of claims that we see in Germany are special purpose vehicles, claims vehicles, which just collect thousands of claims by way of assignments from the consumers or small enterprises, and then they bring those claims collectively bundled in one claim based on these assignments in courts. And I think that is what we will still see in the next closer future.
Thanks, Jen. And interesting to see the challenges that exist in Germany, arguably good challenges in defending certain elements of the German state, of course. Sarah, can I move on to you from an Irish perspective?
Well, I think listening to the buoyancy of the collective or the class actions in these various jurisdictions, I think, Chris, it's appropriate that you've come to Ireland last, and I think probably...
I didn't want to say, Sarah, why I made you sit there.
I think depending on your view of the world, Ireland is probably the least interesting jurisdiction or attractive jurisdiction, or indeed it could be the most desired jurisdiction from a class actions perspective.
Arguably the nicest place to visit, though.
Well, this is it. We're always welcome to tourists visiting. But I think, Ireland lacks probably a universal regime to address class actions in a kind of a consistent or an effective manner. And I think previously we didn't have a kind of a legislative framework or a legal procedure to enable class actions akin to what we see in other jurisdictions. And really, in order to be able to group kind of claims before the Irish courts, traditionally it has been the kind of limited options, for example, pathfinder test cases or representative actions or joinder of parties or consolidation of hearings. So that changed with the introduction of the new regime, and we introduced it in Ireland in April 2024. So we introduced legislation to implement the RAD by way of an act called the Representative Actions for the Protection of Collective Interests of Consumers in April 2024. And that new regime has presented a more streamlined process whereby now we have consumers type actions can be taken in one representative action rather than hundreds or thousands of cases having to be initiated, which would previously have been the case. To date, we have one RAD case coming before the Irish courts. It was initiated in May of this year, and it's progressing before our commercial court, which typically hears cases with a value of over €1 million. It's a case brought by one of 3 qualified entities. So I should say we have 3 qualified entities designated in Ireland, all of which to date are data protection, privacy focused or related. But we're likely to see more and greater diversity in terms of the qualified entities that may get designated status in Ireland. But the case has been brought by one of those qualified entities, namely the ICCL, the Irish Council for Civil Liberties, against Microsoft, alleging GDPR breaches on its online advertising platform. And that's an opt-out injunction type action. It's at a very early stage, so we don't know a great deal about it, but it is likely to create some precedents in this area in Ireland for us. But it is opt-out, as I say, rather than an opt-in damages type action, and the ICCL have said that they are bringing it on behalf of all affected people in Ireland. So, it's, I suppose, one standout difference in Ireland that's probably worth mentioning now is that in Ireland, third-party litigation funding remains prohibited, and that stems from the common law torts and offences of maintenance and champerty remaining on our statute books. And when I suppose that you see litigation funding being a real stimulus for these type of class actions, and you see that in terms of the trends that have evolved in Europe. So I think the fact that we don't permit funding now, we have some exceptions to that. So the Irish courts have recognised that if there is a legitimate interest, if the funder has a legitimate interest in the litigation, that doesn't contravene our laws on maintenance and champerty, for example, a shareholder or creditor of a company, or indeed we have enacted legislation recently. It hasn't commenced, but the legislation has been introduced to permit funding in international commercial arbitration. But we have a loser pays principle, so the stakes are high in litigation in Ireland, and our qualified entities don't necessarily then have a shield as against costs, adverse costs. And in our legislation, our Irish legislation, for consumers who opt in, they may be subject to a nominal fee of €25. So not necessarily a viable source of funds to fund this type of litigation before the Irish courts. And when you see the trends of class actions coupled with funding, Netherlands, Portugal, we've heard, UK, US, I think the absence of funding in Ireland being permitted, and the fact that it's high stakes litigation from a cost perspective, it's likely to have from a practical, it's likely to delay, I think, a real practical impact of the RAD in Ireland. And I should say in terms of anything changing on funding in Ireland, the Law Reform Commission in Ireland has been looking at this issue for a number of years and is due to deliver recommendations early 2026, which may inform any policy change by government. But equally, recent soundings from our current government is that there's no plan to introduce third-party funding. So that doesn't mean, given the apparent focus of funding in Europe post the implementation of the RAD across Europe, it may end up being introduced in Ireland on foot of a European mandate.
Yeah, and obviously the strength of Dublin in terms of large-scale big tech companies that exist in Dublin, AWS, etc., etc. So you'd imagine that jurisdiction will be looking at those types of activities and businesses over a period of time. So it'll be fascinating to see how Dublin particularly, obviously, being the main part of Ireland in terms of business location. Great. So a tour around different jurisdictions, lots of differences, lots of applications of regulations done differently. So I want to briefly touch on the types and shapes of the claims that are present within each of those regimes. So Rita, I'm going to come back to you to talk a bit about Portugal.
Yeah, so Chris, the flip side of my previous answer to your question, and where I highlighted that Portugal is an extremely claimant-friendly regime, is that for defendant-related stakeholders, Portugal is a high-risk jurisdiction due to the number of claims that are being consistently lodged every year. So defendants, businesses' eyes are in Portugal, and we are considered a high-risk jurisdiction for that matter. Portuguese numbers are really impressive. I did some investigation. It's not easy because we don't have a consolidated database with the numbers of class actions in Portugal, but I did some digging. And since 2020, more than 200 class actions have been filed in Portugal. Of course, one are more complex than others and one more sophisticated than others. Not all of them are damages class actions. We have injunctive class actions, declaratory class actions, but this is still, I think, an impressive number. And going back to your follow-up question a while ago, Chris, due to the little controls that we have on abusive litigation and on the fact that Portuguese courts do not assume a gatekeeping role, the vast majority of these claims is still pending before Portuguese courts and will likely reach trial. So this obviously puts a very heavy burden on the Portuguese judicial system. Portuguese courts are overloaded with, and especially the competition court has a very heavy caseload. So this is something that I think that from a public policy perspective should be looked at by the Portuguese authorities. Also impressive is the fact that unlike other jurisdictions that also had a boom in class actions following the transposition of the RAD or their previous national regimes, Portuguese new class action filing shows no signs of slowing down. So we have a steady increase of claims on a yearly basis. To give you an idea, in 2024, at least class actions, 26 class actions have been filed in Portugal. If we exclude the UK, this accounts for 60% of all class actions filed in 2024. In 2025, more or less 15 class actions have already been filed, and according to my calculations, the aggregate amount of damages sought is around 25 to 30 billion euros. So this is an impressive number for Portugal. In terms of the areas where we have been seeing class actions, I have to say that the class action boom started on the competition space with follow-on and hybrid competition class actions, and then it evolved to pure standalone class actions. But this has very rapidly evolved into more pure consumer class actions, and although competition class actions are still a trend in Portugal, non-competition class actions are now higher in number. We have, aside from the competition class actions, we have emissions class actions, we have product liability class actions, we have misleading advertising class actions, we have a very wide variety of class actions. I would emphasize the privacy class actions, that not only for the number of claims, privacy class actions that are currently pending before Portuguese courts. If I'm not mistaken, we have 11 major privacy class actions currently pending in Portugal, but also these class actions also have a very high amount of damages sought. So this is definitely a number. This is definitely a trend in Portugal, and foreseeably it will continue to be a trend in Portugal. Many of the Portuguese class actions, interestingly, mirror class actions lodged in other UK, other EU or jurisdictions, or in the UK or in the US, although the class actions are usually not 100% coincident, because Portuguese claimants are very creative, I have to say. But this shows that Portuguese claimants are also very well connected and very attentive to what happens in other jurisdictions, and bring other jurisdictions' trends into Portugal. In terms of the affected, I'm conscious of time, so in terms of the affected, of the targeted entities, we have several local entities, but also a very big emphasis in international corporations being targeted by Portuguese class action, the big tech, the banking sector, financial institutions. So very interestingly, all 7 DMA designated gatekeepers have been targeted by Portuguese class action. So there is a heavy targeting of the big tech in Portugal.
Fantastic, thanks Rita. And Catherine, could I ask you the same question from a Belgium and the Netherlands perspective?
Yes. So I'll be very brief, because I can see that time is ticking by. For Belgium, of course, we've always had, since a long time, follow-on damages for competition cases involving cartels or alleged cartels, abuse of dominant position and so on, but also consumer protection class actions, as I mentioned before, mainly brought in the past before the RAD by Testacha, the consumer protection organization, in a variety of sectors, including transport, telecom, automotive, including the emissions litigation, of course, Dieselgate, as some people call it. Recently, what we're seeing with the new cases being brought, especially by Dutch claims vehicles, which are now certified as cross-border qualified entities, cases against tech. As you may be well aware, there is quite a lot of new legislation in Europe, like the Digital Services Act, the DSA, Digital Markets Act, the DMA, the AI Act, and so on, which offer more ammunition for complainants to go after tech companies. And indeed, it used to be mainly GDPR, but they're now also using the DMA, DSA, and the AI Act is another one that's coming up, I think, to file class actions against tech companies. In the Netherlands, I have been told by a reputable firm, there were about 25 claims filed for damages in class action cases in the Netherlands since 2020, about 25 under the WAMCA. In the WAMCA, all kinds of claims are allowed, not just consumer protection, but many different types of laws, GDPR, ESG norms, competition law, and so on. I don't have the time to go through all the points that are being currently debated in the Dutch case law and literature. I'm going to focus on 2. The applicability of the WAMCA to more idealistic claims, because in the Netherlands, you don't just, under the WAMCA, need to ask for monetary damages, you could also go for more idealistic purposes, for example, in the case of climate cases and so on. So those are also cases that apparently are going to be brought in the near future. There's been one already, the Shell one, although I don't think that was a traditional class action case, but it also had a lot of media attention because it was the first sort of climate case that was successful. Another thing which I think is very interesting that we're seeing now in cases against tech, you have the allegations of violations of GDPR. And then, I think this is also going to come up in the panel on tech, but you have the question about the interplay between the RAD and the GDPR. I'm going to give you 2 examples, which actually apply to both Belgium and the Netherlands. In the Netherlands, there was a very interesting interim judgment of the Rotterdam court recently in an Amazon case, class action, where the court has asked for a preliminary ruling of the European Court on the interplay between the GDPR and the WAMCA as implementing the RAD. Because they found that the admissibility criteria for a claims vehicle, for a complainant, under the GDPR are not identical under the WAMCA. The WAMCA imposes additional conditions. And then the question is that allowed? Can the WAMCA for class actions involving GDPR violations impose additional conditions on the complainant that the GDPR already does? In Belgium, another problem with the interplay between the GDPR and the Belgian law on class actions is that under the GDPR, you can either bring a case against a defendant with a mandate, or the GDPR also allows a member state to adopt a system without mandate. Now, Belgium has not done that. They just have, under the Belgian data protection law, a system where you can file suit for GDPR violations with a mandate. But our law on class actions is a law without mandate. So, does that mean that a complainant who wants to file a GDPR violation class action in Belgium finds itself in a conundrum? Under GDPR, it must have a mandate, because we didn't adopt a non-mandate clause. But under the class action regime, you can't have a mandate. It's a mandateless class action. So there's very interesting interplays and discrepancies that have been detected in these different jurisdictions. I'm sure it's not just Belgium and the Netherlands, with preliminary rulings being requested from the courts in Luxembourg, which I think are going to be food for thought for another conference.
Thanks, Catherine. And Jan and Sarah are obviously in the markets for Germany and Ireland. Things are developing. So I'm going to combine, in the last few minutes that we have, the last question to talk a little bit about the interest across European regions in the coming months. Is there anything that you believe, and I'll start with Sarah from an Irish perspective, that is developing from a collective redress to keep a watch on?
Yeah, well, I think largely similar to what Catherine and Rita said. I think by reference to the fact that the 3 qualified entities designated to date in Ireland are data protection privacy related, and our first RAD case is also, that data protection and privacy focused tech is probably, a significant area presently. But that said, given the breadth of the EU consumer legislation captured by the RAD, by reference as well to other types of mass claims that have come before the courts in Ireland, or indeed across Europe, and we tend to see what occurs across Europe then translates itself into similar type activity in before the courts in Ireland. So by reference to in sectors financial services, health, consumer goods, ESG, climate related, AI, the new Products Liability Directive was mentioned earlier. So all of that, largely similar to what's probably been experienced across Europe, is also probably on the radar in Ireland as well. I also think, harken back to the point I was making earlier about funding, I think any developments at a European level on the regulation of funding, if and when that may arise, I think will be a significant development in the landscape across Europe and in collective redress and class actions.
Yeah, definitely. And Jan, from a German perspective, what do you see coming down the line in terms of collective redress?
Well, yes, certainly tech claims, as already mentioned. I think 2025 has seen a little shift in Germany away from the main use case of collective redress more towards tech companies, which came into the focus, mostly because of a Dutch Stichting, which lodged 3 of those cases against X, TikTok and Meta in Germany, also pursuing similar claims in the Netherlands and Belgium. So I think that could be something that we see more, like this cross-border enforcement, private enforcement by way of the RED regimes in different member states. And what I would be personally interested in to see whether the future brings more ESG-related collective redress claims. So we are not there, but climate change is something which certainly affects quite a lot of people on this planet Earth, including us. So that could be a good basis for a collective claim, if there is substantively a claim which is actually regarding climate change tested in the Netherlands and also Germany in a couple of cases, and France. So if those cases are successful in the end, so I could imagine that this could be something which develops then more into collective actions.
Yeah, and Rita, obviously you've got a very developed Portuguese regime. Yeah. What do you see coming?
I think that we probably will be seeing more and more competition class actions. We will continue to see privacy class actions. We will likely start seeing class actions on the EU digital legislation space, so the MA and the SA related. And also when the product liability directive is implemented, we will probably see a rise in product liability class actions as well. But one thing that we are all very attentive to, I think across Europe is, and in Portugal particularly, is the transposition of the RAD by Spain. Spain has for many years a draft bill that has not been passed yet, but it is a very well-structured opt-out regime with the certification stage. So they have, they are proposing to implement a very well-structured opt-out regime, which can make Spain a good candidate for receiving class actions and cross-border class actions. And I think that when that happens, that can also be a game changer, not only for Portugal, but for the EU collective redress market. So I'm very curious to see when Spain will pass their draft bill.
Yeah, and Catherine, finally?
Okay, very quickly. For Belgium, I'm sure we're going to have more cases against tech because of the DMA, DSA, AI Act, and so on. Also, I was unable to attend this morning's breakfast session, about PFAS, forever chemicals. I'm quite sure we're going to have class actions on PFAS. At the moment in Belgium, you have some litigation already, but it's very local. It's, for example, a company that has a factory. There was a fire. The local fire brigade arrived, put some foam on it to extinguish the fire. The foam contained PFAS that went to the ground, soil pollution. But when you're going to have more and more science about PFAS and about the way it might affect all of us, you're going to see class actions on PFAS. In the Netherlands, I've been told, they're also expecting more social class actions, the ones where you don't seek monetary damages, but you have a more idealistic purpose, because the WAMCA apparently contains a lighter admissibility regime for these idealistic kinds of claims. And then one last thing I would just like to say, future, and that's especially, I think, important for opt-in regimes, like most of us in Europe. Consumer awareness. Are we going to see more consumer awareness of class actions, and are more people going to opt in? I'm asking this because in Belgium, in October, we had the end date for consumers of the group in the Dieselgate case to bring to opt in if they had bought a certain vehicle with a bit of dodgy software and had not replaced that software. They were entitled to damages, quite a lot, about 1,200 euros. They calculated that about 120,000 Belgian consumers were entitled to compensation. Only a couple of thousand actually asked for it. They opted it. So it's a very interesting question, I think. Are we going to see much more of a payout as well, even with successful class actions? Are people going to opt in? That's another thing that I think we should keep on our radar.
Thanks, Catherine. So to bring it to an end, hopefully that was interesting. One of the things that always resonates in my mind is the European market as a continent is made up of many cultures, many different legislative approaches, and therefore it's a very complex set of regions and countries. So to see things progressing and being challenged and discussions happening across different jurisdictions is very useful. Unfortunately, we're out of time. Oh, excellent. Assuming we've got time to do that. Perfect, thanks.
Would you prefer I use the microphone or just...
I can hear you.
You can hear it?
Yeah,
okay,
that's
perfect. So this is for Sarah Murphy. Is the action against Microsoft an EU-wide injunction representing all EU consumers or limited to Irish consumers and territory?
I'm not directly involved in the case, so I couldn't be 100% certain, but my understanding is that it's domestic. And I think the ICCL have come out and said, or have publicised that they're taking it on behalf of affected people in Ireland. So that's my understanding of it.
Any other questions from anybody? Yes.
And is there an infrastructure that will produce decisions? Because it might surely come to a stop. Many cases filed, but not going through the process and not being heard and no results. I suppose that's just
an observation.
Yeah.
Yeah. I mean, Rita, would you like to respond?
Well, we do have a couple of decisions, as I said, a couple of decisions on merits that refer to older class actions, but no decisions on the merit on the new class actions that were lodged after 2020. Portuguese courts are extremely slow. Class actions are very complex cases, and Portuguese judges, I have to say, were unprepared to deal with such complex cases. Now they are becoming more prepared, so I think that we will probably be seeing cases progressing to trial. But the big issue is that since we don't control the number of class actions at the beginning and at the very early stage, what happens is almost all of them progress to trial, which puts Portuguese courts into a huge pressure. I know that the competition court is making a great effort to progress with the class actions that they are dealing with, but unfortunately we lack the means, we lack the resources, and we lack the specialization for cases to progress swifter. But that time will come. We will have decisions on the merits. That's for sure. If class actions are not settled prior to that, they will come to trial, and we will have decisions on the substance.
Right, it leaves me to say a massive thank you to the panel, a really informative discussion. Thank you for your time.